The Bhima Koregaon case saw reasonably high-profile activists spend a long time in prison. Sudha Bhardwaj, Stan Swamy then dies while this case is still ongoing. Your note of dissent is, of course, well recorded, but it also raises larger questions about one of the key criticisms, not of you in particular, but of the court on bail, right? You have famously said that you have personally given bail from A to Z, or Arnab to Zubair. People have argued that it all depends on which judge hears the matter, and you might be liberal on bail, you might be inclined to give bail, but when the case doesn't go to you, then what happens? And an instance that is cited again and again is that of Umar Khalid. So you did the A to Z, but what about the U? Now, I don't mean to make this about one individual, but I'm using him as an example of how there are cases like that that contradict your own belief that bail should be the norm and not the exception. Do you have some regret that there were cases like that that just weren't actioned in a time frame?
Barkha, I must mention this, that after I took over as the Chief Justice of India, we look at it from the systemic perspective and then answer, individual issues that you have raised. I thought we have to prioritize cases relating to bail and preventive detention. And family cases involving transfer of proceedings, particularly between conflicting spouses. So every single day, apart from Mondays and Fridays when every judge does a whole lot of bail applications, all the other days, every bench was assigned at least 10 bail applications to give them the highest priority. And in the last year, before I demitted office, 21,000 odd bail applications were filed and 21,358 bail applications were disposed of. So at a macro level, at a systemic level, you see that the Supreme Court has been extraordinarily proactive in attending to cases dealing with bail. Now, coming down to specifics, a particular case or couple of cases.
Start with Bhima Koregaon because your dissent note is on record there.
Of course. Now, one thing you have to understand is that the Supreme Court is, as it is called academically, a polyvocal court.
Right.
Right? We are not like the US Supreme Court where 9 judges sit en banc. That was not the model which our founding fathers and mothers adopted when the Constitution was framed. So we have now, at any given point of time, about 16 or 17 benches, 34 judges. Chief Justice sits normally in a bench of 3. Or even if the Chief Justice sits in a bench of 2, you can't have more than 17 benches. Now, therefore, when you have a polyvocal court, there has to be a degree of acceptability of the fact that, yes, all judges are conscious of the fundamental principles underlying the grant of bail, which is a presumption of innocence. 2, the parameters for the grant or denial of bail are extraordinarily well settled. But at the end of it, whether a decision to grant bail would be made would depend upon how that court feels at that particular moment.
But you're the master of the roster, right?
It doesn't work like that. Barkha, can I deal with that straight away, the master of the roster issue?
Yeah.
Individual cases are never assigned by the Chief Justice to individual judges. The way it works is this in the Supreme Court. The Chief Justice provides for the roster in the sense, say judges, court numbers 1, 3, 7 would be dealing with direct tax cases. Almost all judges in the Supreme Court deal with criminal cases because the largest inflow into the Supreme Court is of criminal cases. So the roster includes almost 99% of the benches would deal with criminal cases. I said 99% because sometimes the tax bench may not deal with a criminal case because you want that tax judge to be doing only the revenue cases, right? Now, what happens is, once the roster is published under the authority of the Chief Justice, and it's periodically revised after 6 months or when there's a retirement, because that roster of the retiring judge has to be assigned to other courts. Within the roster, the allotment is made randomly by the computer. It's not that. You wouldn't be able to do that. Physically, it's impossible for the Chief Justice. There are about 1,000 new cases which are coming into the court every week. About 1,000, 1,100 cases are being assigned to judges. If the Chief Justice started assigning 1,100 cases, there would be no other work which the Chief Justice would do. The area where the Chief Justice does have a discretion is, for instance, where a judge feels that, well, this case has come to me under the computer allocation, but I believe that another colleague has dealt with the same issue.
Right.
In which case, let the papers be placed before the Chief Justice to assign this case to that other judge. Alternately, if a judge recuses, or if there's a divergence between two benches, in which case, the benches will say that please place the papers before the Chief Justice, so that the Chief Justice can constitute a bench so that this divergence can be resolved. That's the area where the Chief Justice really has an element of discretion. So ultimately, cases are allotted in terms of a random allocation. Now, this I have learned as a lawyer, even when I was a lawyer appearing before the High Court. We had judges who were very liberal in terms of, say, rights of labor. Other judges felt that there was a greater need for discipline in the industrial workplace. There were judges who were more liberal in the grant of bail.
Yeah.
There were judges, this thing about liberal and conservative is not the politically liberal and conservative. It's just the way judges exercise their discretion. Second, when we are talking about the grant of bail, it's always important to understand that there's not merely the presumption of innocence of the accused, but the wider societal interest as well.
Right.
Namely, the need to protect society against crime. I'm not dealing with any particular case here. Now, every judge, while taking this decision, has to basically look at a few things. First, is there a prima facie case? Two, what is the stage of the trial? Is the trial likely to be interminably delayed, in which case you don't want to keep a human being behind bars? Third, is there a likelihood of the accused fleeing from justice? Fourth, is there a likelihood that the person, if they are released on bail, may tamper with the evidence during the course of the trial? Now, these are some of the issues which are dealt with by judges. I'll give you another example. You deal with these NDPS cases. Now, most of these drug cases, or a large number of them, deal with petty offenders, a truck driver, a cleaner. Now, there are very stringent provisions under the NDPS Act governing the grant or denial of bail. Now, notwithstanding that, we ask ourselves as judges a fundamental question. How long is this trial going to take? How many witnesses are there? Are there, say, 50 witnesses? Is there any chance of the trial being concluded within a reasonable period? If there is no chance of the trial being concluded within a reasonable period, you have to grant bail, notwithstanding the stringent provisions of the law, because Article 21 of the Constitution is fundamental. And to my mind, this is a basic principle which every bench should and does apply. Now, within that spectrum, obviously you have different people deciding cases with their own experiences
with their own
of life.
lens. So what happens is, what the layperson sees is a Ram Rahim who is standing trial for rape, getting multiple parole visits because he's politically powerful. And in Umar Khalid, this is what the layperson sees. Now, this may be, as you've explained it, the lens of that particular judge, the lens of that particular court. But there seems to be a great unevenness in which this principle is applied. Would you concede that?
Not really. Now, since you mentioned Umar Khalid's case, and I don't want to comment on the merits of the case.
Yeah, I'm not commenting. I'm using it as an example.
But I must tell you one thing which is lost sight of by a lot of people when it comes to Umar Khalid's case. Can you imagine that the case was adjourned? There were at least 7, if not more, adjournments which were sought by the counsel appearing for Umar Khalid, and eventually the application for bail was withdrawn. So what do you have to say to this? That when, on the one hand, lawyers appearing for the accused repeatedly ask for adjournments of cases before a judge, and then you withdraw a case, can then everybody, can a segment of the bar or civil society say, or they must be at least told that, look at the record. Here was a case where someone appearing for the accused has repeatedly sought time before the court. Why? Why this reluctance to argue a case? either you argue it on the first day or you say that, well, I don't want to press my application for bail. I'll reserve my application for bail before the High Court or before the District Court, as the case may be. But in Umar Khalid's case itself, if the record is seen, it would show that repeated applications for adjournment was made before the court. Now, at the end of it, what happens is, particular perspective is conveyed on the social media and in the media. Judges have no place to defend themselves.
Yeah.
And if you look at really the fine print of what happens in the court, reality is a little more nuanced than what happens.